Welcome, everybody. Thank you for joining us for the New England Legal Foundation's CLE for the states of New Hampshire, Maine, Vermont, Rhode Island, and Connecticut, and of course, Massachusetts, which does not have mandatory lawyer CLE. Everybody from Massachusetts is always welcome. My name is Dan Winslow. I'm the president of the New England Legal Foundation. With me today is our manager of membership and events, Elizabeth Miner. Elizabeth Miner will be handling the follow-up on CLE, and she'll be in touch with everybody. Every state is a little bit different, so we'll be coordinating through Elizabeth with respect to everything that needs to be done for CLE credit to be assigned. I do want to tell folks that this session is being recorded, and we will be posting it in due course on the New England Legal Foundation website, which is newenglandlegal.org. At the end of the session, at about 10 minutes till 5 p.m., we will set aside some time for audience Q&A. And at that point, all you have to do is hit your raise hand icon, which is if you click on the three dots more at the bottom right of your screen and then click on raise hand, you'll see the way to raise your hand. And we'll do that, set aside the last 10 minutes for that purpose. I want to just start off the session by introducing you to our three panelists. Our first panelist that I'll introduce is Justice Catherine Connors from the Maine Supreme Judicial Court. Justice Connors is a graduate of Northwestern University, undergraduate as well as its law school. And after clerking for Chief Judge John Grady of the U.S. District Court, the Northern District of Illinois, she became an associate and then a partner in the Maine law firm of Pierce Atwood, focusing on motion and appellate practice. She was appointed to the bench by Governor Mills to the Maine Supreme Judicial Court in 2020. Welcome, Justice Connors. Wonderful to have you here.
Thank you.
We also have with us from the Massachusetts Appeals Court, Justice William Meade. Justice Meade's career includes service as an Assistant Attorney General in Massachusetts, where he served as the Chief of the Appellate Division, and then also as a deputy legal counsel to Governor Mitt Romney when he was served as the governor of Massachusetts. And then from 2005 and 6, he was serving as the legal counsel to all 11 district attorneys in Massachusetts, at which time he was appointed to the bench by Governor Romney. He has been a senior lecturer and coordinator of the clinical program at Harvard Law School, editor-in-chief of the Massachusetts Law Review, and he's taught numerous CLEs, most recently as an adjunct faculty member of the Suffolk Law School, where he teaches appellate practice. Thank you, Justice Meade, for joining us here today.
Thank you.
And last but not least, I want to introduce you to and thank for suggesting this panel, Josh Dunlap, a partner at Pierce Atwood. Josh is a member of Pierce Atwood's litigation team, and he's the co-chair of the firm's appellate and amicus team, focusing his practice on civil litigation at both the state trial and appellate levels. He's appeared in state court as well as federal court representing clients in a variety of commercial litigation matters. He got his start earlier in his career clerking for the Honorable Paul Kelly in the U.S. Court of Appeals for the 10th Circuit. He's admitted in multiple courts of appeal in the U.S. Supreme Court, and he defends clients on complex litigation, including class actions, multi-district litigation, breach of contract claims, unfair trade practice claims, as well as constitutional issues. Josh, thanks so much for joining us here today.
Thank you, Dan. It's a pleasure.
My first question is really to the judges, just to kick things off. As a threshold consideration, does oral advocacy and appellate advocacy generally, written as well as oral, make a difference in a close case? Justice Connors, what's your sense of that?
Well, you really don't want me to say no, do you?
I really don't. Otherwise, we can get a short seminar.
Well, yes and no. I mean, the no part is hopefully we pick up what the issues are without the help of particularly good advocates. But I'll tell you where it really makes a difference is in whether we're going to grant you an oral argument versus deciding it on briefs, and whether you're going to get a published decision or whether you're going to get what we call a mem deck. So I would say yes, and even if it doesn't get applied to those situations, it does. Hopefully not, in earth-shattering ways, but it does.
Well, thank you, Justice Connors. How about you, Justice Meade? From what's your take on appellate advocacy? Does it make a difference in a close
Well,
case?
as an appellate lawyer, I always hoped that it did, and as an appellate judge, I can tell you that it usually does. The best appellate advocates are able to answer the court's questions, clear up any of the concerns, factual or legal, and do their best to distinguish case law that's against them and emphasize that favors them. So it usually helps.
Now, as between oral argument and a brief, Justice Meade, do you find that one or the other is particularly helpful to you in reaching a decision?
Well, the brief. I mean, the brief really sets the stage for the appeal, and the overarching purpose of the brief is to make the court's job easier. And the most important way to make the court's job easier is brevity. I'm not sure what the argument caseload is in Maine, but we'll hear 6 cases generally. And if everyone writes a 50-page brief, well, that's 600 briefs, 600 pages of briefing, and that not including transcripts and appendices and whatnot. So if you can make your point and make it quickly, it's very helpful to help us understand your case and perhaps rule in your favor.
Justice Connors, is that your experience as well, that the briefs more so than the oral argument, persuasive in tipping the balance one way or the other for your decision?
Yes, and I will agree that we are very busy people, that if you can be concise, that will be helpful. But I will tell you that everybody always asks, does oral argument ever change the way you're going to come out? And a lot of oral argument is just confirming, when you have questions about facts and just making sure you're doing it right, which is important. But there have been situations where I've gone in thinking I would go one way, and when I came out, I went a different way.
That's great. Well, thank you. Before we focus on what lawyers can do to prepare for this highest level of appellate advocacy, I'd like to understand what judges do. What judges do to prepare to do the job of judging as you approach a case. Justice Connors, could you share with us sort of how you approach a case?
Well, I'll tell you, I'm going to be very concrete. So whether I'm at home or whether I'm in chamber, I have 3 monitors. And so I've got the brief on one, I've got the notes I'm taking on another, and then the other one can be the appendix or some other things. And I think if you're an appellate lawyer, and especially the appellant, you want me to start with your blue brief, go through your entire blue brief, and then start looking at other things. So what you don't want me to do is stop reading your blue brief and go wandering off to other things. So if you want that to happen, you've got to tell me up front, what is the issue? Because I'm taking my little notes, what kind of case this is, because if you don't tell me up front, I'm going to go somewhere else to find the answer. And if you don't give me a parenthetical next to the case that you're citing, I'm going to be going, well, does it really stand for that position? And it's very easy for me to go to that 3rd monitor and just click and see what the case actually says. So have a logical progression and make sure that I'm following an easy path, lots of subheadings and road mapping if you want me to keep reading without going off to the decision below, which you lost, or going off to the red brief, which is the other side. So make it clear, make it concise, and make it flow.
Thank you, Justice Connors. And Justice Meade, how about you? What's your approach to doing the job of judging when a case comes before you?
Well, the first thing I'll do is I'll take a look at the table of contents in the appellant's brief and see what the issues are, or maybe even a summary of the argument. Then I'll find the judge's decision from the trial court, if there is one, and I'll read that. And then I'll read the statement of facts in the appellee's brief. And then I'll read the appellant's argument and facts, and then of course the appellee's arguments in response. And then I'll if necessary, and this is all before argument, I would read transcript if I can. Certainly things like a motion to suppress or something with a limited record or critical documents. And then if I have to, I'll do some preliminary research, or if it's in an area where I didn't have any expertise and haven't gained any in the time I've been on the court, I'll go. The wonderful thing about our court is there's 25 of us with very diverse backgrounds. So I'll go find someone who's an expert in say probate court and talk to her and find out what I need to know.
That's great. And Josh, as an appellate practitioner, is there a strategy that you would suggest for choosing issues on appeal? Is there a difference, for example, between how you frame the issues in the brief and what you focus on for oral argument?
There is, and I would say that making your choice of what you're going to appeal, what your issues on appeal are going to be, is really the major strategic consideration that you should take time to focus on. And really, this is one of the key areas where it can be helpful to have some appellate counsel involved, because you need to identify your key issues. And in doing that, you should be thinking about your standard of review. Is there going to be deference on a factual issue? Are you going to have de novo review on a particular legal issues? Where are your greatest chances of success? And you need to hone in really relentlessly and be willing to jettison any pets that you may have. Because at this stage, emotional attachment to an argument really isn't helpful. You need to be able to objectively analyze your strengths and your weaknesses and be willing to set aside those that are just going to take up space in your brief, perhaps cost you credibility with the court. So credibility is everything. And so you should be making sure not to waste it on undeserving arguments. So to the latter part of your question, I do think it changes as you go, even from trial to the appellate stage, which I was just talking about, and then even from brief writing down to oral argument. I think of it in terms of a funnel where you keep narrowing your focus. You shouldn't likely have everything that you argued at trial. And then at oral argument, you should be picking your strongest points that you want to make sure to be able to touch on before oral argument closes. So you should always be refining as you go through the process.
So Josh, if the trial judge committed clear error on a tangential issue and arguable error on the bet the company issue, would you say that you sort of lead with the tangential issue to sort of get some credibility, get some momentum going, or is it better to just hit it as hard as you can with your important issue, albeit with a weaker argument, and maybe discard some of the more tangential points on appeal?
So this one's a judgment call, and you touched on a couple of the key considerations. I would often think of this in terms of building momentum. So if there's just a clear mistake that the trial court judge has made, you can potentially build that momentum with setting that up early and addressing that, and then moving on to your key argument. That said, and the judges have already referenced this, every court has a finite amount of time and patience, so you don't want to bury the lead. So if you think you could win a number of issues but still really lose the case, you need to make sure that key argument comes early, so that you haven't lost steam by the time the court gets to that key issue.
Okay, thank you, Josh. I just want to turn to the briefs for a moment now. Other than brevity being the soul of wit, Justice Connors, what are the kinds of things that you find are most helpful about briefs? You mentioned earlier maybe sort of breaking it down into bullets or topic headlines. Any other pointers on brief writing to be helpful to the court?
Well, I can't emphasize enough how you want to organize it in a way that can be easily followed. And I will say that before I got on the bench, I was basically Joshua's predecessor, and I spent 30 years being an appellate lawyer, a lot of appeals in front of the law court. So I know how you have 12 issues and you want to assert 12 issues, and you shouldn't assert 12 issues if you can possibly, but you're going, I don't know which one they're going to, yes, we'll try to be choosy and look at the standard of review. But you should remember also that, especially if people are reading briefs online, and they're doing more and more these days, people read in an F shape. So their brains will read the heading and then the next heading. you have to do a lot to make them read the block in between. So make sure you have lots of headings, break it up. If you have a diagram or a photograph and it's in the record, even if it's in the appendix, you can stick it right into the brief if it's really important. So I would think about making your brief as readable as possible.
Justice Meade, is it your sense as well that you find that non-textual content is helpful too, or do you have a different experience?
Well, I don't see a lot of that, to be honest. I mean, just to touch back on something that Josh and Justice Connor said, the don't take a shotgun approach to issues. It's not a law school exam where you can spot as many issues as possible. You want to pick one, two, or two or three is really the best way to go. And of course, you're gonna, as Josh said, you're looking at the standard of review. Is this, if it's a civil case, I wouldn't be spending a lot of time on something that's not preserved, because it's probably going to be waived in any jurisdiction. As far as what helps for me in brief is I really like to see even in a one issue case, I'd like to see a short introduction in the statement of the case that tells me what this is about. Is this helpful to the lawyer writing the brief? No, of course not. They know what their case is, but I've got 6 others to read for that sitting, and I'm like, oh, this is the one with the guy who drove into the tree. Those sort of things that are helpful. The other thing that's having been in the government for so long, I'm always looking for procedural problems in cases. As a government lawyer, nothing made me happier than a procedural problem that make a case go away. It's a habit I've never broken. So for me, I want an extremely accurate statement of the case. I want to know the exact procedural path of this case, when it happened, when the judgments were entered, orders that are at issue, and I want every single sentence in that brief, especially in the statement of the case, supported by a citation to the record, because I want to be able to find that, and I want to be able to find it quickly.
Josh, Justice Meade had mentioned that he likes to look at the table of contents as he's sort of diving into a case to begin with. Is that your experience as an appellate practitioner, that the table of contents itself can be a summary or a form of argument or persuasion?
It is, and I would say that the table of contents itself should be an advocacy piece. And it was interesting to hear Justice Meade mention sitting down and reading that. That was one question I was thinking of for the justices is, do they in fact treat it this way? Because the way that I think about it is that you should be able to sit down, read the table of contents, and have a clear roadmap of the entire argument, so that all the critical elements of the argument are reflected in headings and subheadings. And this means that you should be, in my view, pretty generous with your headings. Break down your argument, state your key conclusions in those headings. And I think this can be a valuable tool, not only for the judges who are going to be reading the brief, but it can also make you kind of force you into thinking in an organized manner to make sure that you've structured your argument in the most persuasive way. And so to make your headings helpful, I think you need to make sure that they're readable. I see a lot of all caps type headings, which are just impossible to read. So avoiding all caps or capitalizing the first word of every, each word in the sentence, avoid that. There should be a full sentence written in a typical style, explaining each of your key points. And I think road mapping in that way, I think, should help the judges follow your argument.
Can I just add something on that, Dan?
Sure, go ahead.
It's important to have good argument headings that has necessary facts and the standard of review, as Josh said. But again, if your argument heading is 3/4 of a page long, it's in all caps and bold, my eyes are going to glaze over, and I'm not going to read it. And another good test is if you can't read it out loud in a single breath, it's too long.
That's a great test. I just have this image in mind of Justice Connors with 3 screens: the brief, the notes, and then that other thing. and I've seen in other jurisdictions, I'm just curious what the practices are in Massachusetts and Maine, at least, if for using embedded links in a brief for case citations or record references, because I think it would warm my heart knowing that if Justice Connors saw something in my brief and she clicked on it, it would immediately pop up on her third monitor. But is that the practice in Maine? Do you allow embedded briefs or embedded citations, embedded record references?
We don't have a rule on it. People don't do it. You can't do it with the record because we're still Luddites and we don't have the record in shape for you to do that. And it's probably not necessary for the cases because it's so easy for me to just go off to Westlaw. I will tell you though that it's my understanding from courts of appeal, federal courts of appeal, where they have more resources and everything is electronic, that my understanding is at least some of those courts, before the brief gets to the judge, somebody puts in all those hyperlinks.
That's
So the
interesting.
judge can just go click, click, click.
That's interesting. Justice Meade, does the Massachusetts have any practice that you're aware of along those lines?
I think like we don't have a rule like Maine. I don't see it that often. I'm reluctant to click on them. My IT people would have a heart attack if we're just clicking on links here and there. But like Justice Connor said, it's so easy to do it on the side when I want to look. I'm not going to read any case links citing the standard of review.
That's great. Before I leave briefs, I just want to go around the table here. Any further do's and don'ts about effective brief writing? Josh, we'll just start with you.
Yeah, I would make a couple of points. You know, when you're writing a fact section of the brief, you know, I would say avoid argument because you're going to lose credibility if you're arguing in the fact section. But use that opportunity to persuade. You don't have to draw conclusions, but you can explain the facts that will support your conclusions ultimately. So you can essentially draw the judge to the conclusion. You can show rather than tell. And I think you should be taking care to write your fact section in that way. You know, nothing is more refreshing to me as an appellate practitioner than reading the first part of an opposing brief and saying, well, there's nothing in the first half that I need to respond to. So you should be persuading all along the way. You know, also, don't fall into the trap of using adjectives or adverbs. You know, hyperbole in fact sections, I think, can really kill your credibility. And then, you know, think creatively about how you organize your fact section. You know, chronological is often the right way to go and is probably the default. But there are times when an explanation that isn't strictly chronological may make the most sense to put your case in its best light. So you should be thinking about that. And then, you know, disclose your bad facts. I think you need to put them out up front, put them in context, and then you'll be able to argue about them later. But hiding from them, I think, only costs you credibility.
That's great. Fantastic. Justice Connors, anything further on briefs before we turn to oral argument?
Well, I agree with everything Josh is saying. And I will also say, I was taught by what is now Judge Kayada of the First Circuit. And he basically said, your statement of facts is to show that something went wrong. Something needs to be fixed. And the legal argument is, this is how you fix it. So your fact section should be a story about there's something unfair here without saying that. It's all in how you order the facts and make sure you get all the facts in. But you want to have a sense of something has to be done at the end of the fact section, and then here's how you fix it.
And Justice Meade, any further thoughts on briefs?
Also on the statement of facts, I think things to think about that makes it easier for the court is one, you don't want to ever write a statement of facts that merely summarizes how the story unfolded in the perspective of each witness. You're not writing a Quentin Tarantino script. The best, it's confusing too, and you've lost your chance to tell a coherent story in a narrative fashion that helps tell what occurred at trial or the proceeding underneath. It's also use subheadings to break up the narrative. It makes it easier to read and keeps you organized. you want to use parties' names and titles, taxpayer or landlord, and don't use appellee, petitioner, defendant, appellant. You don't want to make me flip to the front of the brief to find out who you're talking about. And then this unfortunately happens too often, is you don't want to misstate the facts. It's not advocacy and it's not ethical. I was happy to hear Josh say something about credibility, because your credibility really is currency in this business, and your opponent's going to bring it to your attention, and that will negatively affect your credibility.
Thank you, Justice Meade. I want to turn to oral argument now and engaging in appellate advocacy and oral argument. I'll start first with the judges in terms of, what are the attributes of excellent oral argument? What distinguishes a brilliant oralist from a mediocre oralist in your experience? And Justice Connors, I'll start with you.
Well, I mean, the oral argument, the arguer should remember, isn't for you, it's for me. And so that means I have questions and you want to know what my questions are, because you don't know what we're thinking, and you want to know what we're thinking because that helps you persuade us, which means the best oral argument is a dialogue. And so you should do whatever you can to invite questions, whether it's your body language and certainly being quiet when somebody starts asking you a question, answering a yes or no question, yes or no, yes, but, no, and, but yes or no. And then if you want to be really, really good, I have found that if you have like a sentence or two left in your, that kind of summarizes everything, save something for your rebuttal and have a whiz-bang ending for your rebuttal if you are the appellant, because if it's the last thing that's resonating in the judges' heads as they go off the bench. So that's helpful. And in terms of preparation, I would say what I found useful, although it's a lot of work, is what Justice Roberts did, he was an appellate lawyer and he was pretty good for a long time. And he would try to predict every question that could possibly be asked, put the answer and the question on a note card. So it was a short answer. And then it was in his brain that he could then share very concisely anything that came up. So that's how Roberts did it. And so that's what makes the great oral arguer.
It worked out for him, for sure. Justice Meade, what are your tips on excellent appellate advocacy?
I heard Chief Justice Roberts talk about that. Not only do them on the cards, but he'd shuffle the cards so he could do them in any order and start anywhere, and that he keep him from feeling like he's stuck to a script. There's a trend in some jurisdictions that allow this opt-in period of uninterrupted questioning at the beginning of an argument, that you can give your spiel without any questions being asked of you. And and I've spent a total of almost 35 years on each side of the podium, and I think and Justice Connors touched on this. This is a fundamental misunderstanding of the purpose of oral argument. It's not about you, as she said. It's about us. It's about the court. You're not giving a valedictory speech. This isn't your moment in the sun. This is your opportunity to convince three or more very busy judges why you have the best of the argument. And only the best advocates understand this. And if you want to have 5 minutes of your time squandered on talking about what you want to talk about, we don't have any interest at all, I'm sorry, you've wasted your time with that. I think the other points that were touched on before, but the best arguments are a conversation. It's not a conversation among equals. When one of the judges starts to talk, you stop talking. You need to learn how to stop on a dime. You have to be conversational, and you have to be honest about your case. Again, your reputation is currency in this business. And we all know that lawyers talk about judges, but guess what? Judges talk about lawyers. you want to be the one that we look forward to seeing and that we trust.
Thank you, Justice Meade. And Josh, in terms of prep as between being a trial lawyer at closing argument and an appellate lawyer at oral argument, what's the difference here in terms of your experience?
Yeah, and there is a difference. I think that's important to recognize, and it's one of the key reasons why having appellate counsel can matter for an appeal, because the approach is different and a different set of skills are required. The closing at trial is often very factually detailed. It's emotionally impassioned. You're persuading laymen. You're telling a story and trying to draw people into that story. But the tone is different at oral argument. It's a little more removed, a little bit more analytical. You have a different audience, and as anybody knows who has a job in communication, you have to know your audience, and you have a very different audience when you have a panel of appellate judges that you're speaking to. And the tone that you should strike there, I think Justice Meade and Justice Connors have already touched on this. You're trying to foster that dialogue, trying to have that conversation. The thing that makes me happy as an appellate lawyer is when I feel like I'm getting a read on the judge's honest questions, and I have the opportunity to address those questions, because that's when you have really the opportunity to persuade. So if you're speechifying, at this stage of the case, you're going to be having trouble.
Josh, do you think there should be some level of formality in this dialogue, though? It starts off, may it please the court, or good morning, judges. how do you kick off?
The Justice Meade touched on it, and he's absolutely right that it is a dialogue, but it's between people in different stations, in different roles, and so it is one that requires a deference to the court, and so I think it matters to take some of those steps of saying the things like "May it please the court." It acknowledges kind of where you stand and the role that they play, the very important role that they play in deciding cases. But I think that there can be a good balance struck between showing that deference and engaging in a conversation back and forth. And I think you hear that in the best advocates. When you hear the Justice Roberts of the world presenting at the Supreme Court, they're having a respectful but a clear dialogue with the judges.
So we have a number of people in the audience at the CLE of varying degrees of experience. So for those that are relatively new at this, when you get as far as may it please the court, and that's the last time you have a chance to actually read anything from your notes, that's called a hot bench. And I'm curious, Josh, from your point of view, is there such a thing as a bench that's too hot? How do you handle a hot bench?
Yeah, in general, I would say no. There really isn't a bench that's too hot, insofar as that means that judges are asking a lot of questions, because to have this sort of dialogue that we're talking about, you have to have a two-way street. So I like having a lot of questions. The difficulty comes, I think, when not when there's too many questions, but when the judges don't give enough time to answer the question, which happens from time to time when you're presenting argument. And to have a successful dialogue, you have to have this conversation, a two-way street where the attorneys have the opportunity to answer. But for the attorneys presenting, what that means is you have to be ready with a concise response. Because guess what? If you're 45 seconds into a response and you really haven't given a good, clear showing of what your response is, then the judges are going to cut you off and try to redirect you. So as Justice Connors mentioned, that yes or yes but response, it gives the quick response, but then you can expound on it. So you need to be concise. You need to know your case inside and out. Moot if you can, because that helps you create a concise response, and then refine those answers to the card, like Justice Connors has already mentioned, so that you have a pithy response. Because if you're too long-winded, the judges just won't have patience for it.
So the practice varies from appellate court to appellate court. Some courts will confer or have a ensemble before oral argument. Some will only do it after oral argument. Some after maybe a draft of a brief is done. Justice Connors, what's the practice in Maine? Do the judges compare notes before they go out on the bench for oral argument?
No. The way it works with us is that there's a justice who's assigned the case, and a clerk for that justice writes a bench memo. So, and the bench memo takes a position. You know, you should rule this way on this issue. So we know what one clerk thinks, but we don't even know what that judge thinks, because the bench memo doesn't necessarily reflect what that particular judge thinks. And then we don't really talk about how we're, how each of our positions until right after the oral argument. That's when we go off the bench after each argument, usually, and we discuss it then. And it's a preliminary kind of discussion and vote. And then you hunker down with the circulation of the opinion, and the rest comes in writing. And sometimes we reconference when we are all over the place, or something isn't clear. So not a lot is front-loaded before the argument.
Justice Meade, what's the practice in your experience here in Massachusetts?
Similar to that. I mean, if we're in the robing room, there might be some informal discussion about something we're going to hear, but generally we'll just hear the case, and then we'll break afterwards, ensemble the cases immediately, and usually, if not disproportionately, we'll find the consensus among the three of us, and then we'll go about writing. And as Justice Connor said, sometimes when you get to the process at some point, and you realize that the case can't be decided the way you thought, and then you're supposed to go back and resample it, and rather than getting a draft from one of your colleagues that comes out differently from what your ensemble notes say, which can be frustrating.
So Justice Meade, does the Massachusetts Appeals Court have a bench memo going in that's written by one of the judge's clerks or the assigned judge's clerk, or is it not?
We do not. No, and I don't.
Okay.
I don't have my clerks write bench memos. I'm going to read everything anyway, so I see that as busy work for my clerk.
Now, I'm curious from the judges, speaking of hot benches, when you have a hot bench and one justice is sort of asking questions that are pointing in one direction and another justice is jumping in, and essentially through you having a debate with the other justice, it's a good thing, I imagine, because you're getting some sense of what the justices respectively are thinking about. But how should lawyers handle that? Should lawyers handle that the way they would any question from any judge, or just play it straight? Do I give more deference to the judge that's going my way and highlight their point of view? What's some tips that you would share?
Well, you're never going to know what's going on, because just because one judge is saying one thing, they don't necessarily even believe what they're asking. And I remember I had an oral argument in front of the law court once, and I spent 20 minutes. We had 20 minutes at that point on each side. I was just buffeted between one judge saying, you're going to lose, and the other one saying, no, you're going to lose. So two judges were saying, you're going to lose, you're going to lose, you're going to lose. And you respond as best you can, you keep fighting. and then in the end, I won. And it was, two people dissenting. So when you're just getting beaten up, that means maybe the other ones all agree with you. And if one's going one way and another one's going the other, you just do your best to answer them and know when you're getting a softball. Because one side may be asking you a question. You have to know, when to concede and when you're getting a softball. And beyond that, you just have to let the judges talk.
That's interesting. Justice Meade, is that your experience as well? There's from time to time a judge may lob a softball to counsel to get them redirected.
Well, if it doesn't hit them in the forehead, the hot, as a hot benches are from a lawyer perspective, a hot bench is fine because they're engaged and they're well prepared. As a judge, when the bench is so hot that the lawyers don't get to speak, it's very frustrating for me. because I can listen to my colleagues at lunch or at Ensemble. I want to hear what the lawyers have to say. So yes, lots of questions are good. If you're getting multiple questions at the same time, when I used to argue cases in our SJC, that would often happen. And if you're there a lot, you get to know who's who. And if someone's asking a question that doesn't matter, you can make eye contact with another more friendly judge, and she can redirect us to what's really important that's going on. And that's all comes with experience and being a frequent flyer, and having the respect of the court. But even on the bench side, when I see one of my colleagues think that it's important for him or her to make a lengthy speech, at the end of which the poor lawyer goes, "Is there a question in there?" And I just laugh out loud because I can't find one either. And sometimes with some of the usual suspects, before we go out on the bench, I'll say, "We're going to let the lawyers talk today, aren't we?"
By the way, just on that, when you have a really hot bench and the lawyers haven't had a chance to really get a word in edgewise, yes or no, fair bounds to say to the chief or whoever the presiding judge is of the panel, may I have 2 minutes longer of my time? May I extend my time 2 minutes longer, or the time limits just locked and loaded? Justice Connors,
In our court, maybe you'll be allowed to finish your sentence. Do not ask for more time.
How about you, Justice Meade? What's the practice?
I understood from something Justice Connors said earlier, they have rebuttal. We don't permit rebuttal in Massachusetts. And as far, I'm pretty strict on the clock. However, if one of my colleagues hasn't got the answer to a question, or has another question, as it happened today, I let it go longer. Especially if I know the case is assigned to him or her. I'm not going to cut off a lawyer who's being helpful.
Right. Yeah, so you would extend, but really it's for the justice's benefit, not necessarily for the lawyer or the party's benefit.
Yes.
So I just want to go on oral argument before we turn some of the common errors or pet peeves that each of the three of you have seen in your experience. So we'll start with you, Justice Connors. Common errors or peeves on oral argument that you would suggest counsel steer clear of?
Okay, so here's one that I don't know why you would know this. And so, hey, you signed up and you learned something, at least in front of the law court. It is a pet peeve amongst some of the members of of our court. If the arguer says, respectfully, yada, 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 because that is just a signal that they're going to be not so respectful, maybe. So try to avoid saying the word respectfully. Beyond that, you should shut up when a question is being asked, and you shouldn't say things like, "Oh, I'll answer that later," or if you're splitting your time, which is a whole other issue, don't say, "Well, he's going to answer that one. I'm just going to talk about this." And last, we can be funny and you should laugh, but don't try humor yourself. I mean, you have to be really good and it's not worth the risk. So don't try to be funny.
So is, with all due respect, the second cousin to respectfully, Your Honor?
I would just, they're noise words. They're going to use up some of your time.
Fantastic.
You can say you disagree and just don't sound like you're nasty about it. And we will not take umbrage if you disagree, but if you say, respectfully, I disagree, it's just going to make some of the judges go, yeah, okay.
Justice Meade, any pet peeves or common errors in the oral argument?
The biggest one, and I see it all the time, is when the lawyer doesn't answer the question. I mean, it perplexes me to no end why they'll either try to avoid it, dodge it, or as Justice Connors said, I'm gonna get to that in a minute. I'm like, no, I'd like you to answer it now, please. The questions reveal. It may reveal what the judges are thinking and reveal what their concerns are. And you're an advocate. This is your opportunity to address them. So you don't want to avoid it. And again, answering the questions increases your credibility. And as Josh and Justice Connors said, you answer it yes, and then explain yes, but, or no, but let me explain that. And because if I don't get the yes, then I just hear a lot of like mumbling for a while, and then I'll go, let me ask again. And it's incredibly frustrating. And a good advocate listens to the question, figures out in their head where their intended argument was going to hit on this, and then weave that argument into the answer to your question. And you're talking about what you want to talk about, and you're answering the judge's questions. The other things that you have, again, and Justice Connor said something similar to you got to stop speaking when the judge asks a question, and you don't talk over the judge when he or she is asking a question. I call that the filibuster, or worse, when you pose questions to the court. That's a huge no-no. And I've seen a former colleague of mine who's on our SJC dress down a lawyer for doing just that in a very brutal fashion, that you don't want that to become your problem.
And Josh, any tips from you in terms of errors or pointers for oral argument before we turn on to the next topic of the few minutes remaining?
Well, along the lines of what Justice Connors mentioned, another one that I would avoid is saying that's a good question, because presumably the judges think that it's a good question. That's why they ask. Now, I think it may be acceptable to say something like, I think that's a key question, because it indicates something about how you view the importance of a particular issue. And then you can go on to explain why you believe it's key and how it should be answered. But I would avoid that common hazard. And then one thing that we haven't talked about a lot is how to handle the cold bench. And one mistake that you can often run into is just by talking too much. You should know your key points. You should make those points. But if the judges aren't asking a lot of questions, know that it can be okay just to sit down, because you can walk yourself into a lot of trouble by talking about something that you didn't need to talk about. So just know when to sit down.
What's your practice, Josh, if you have a case that's been argued as pending decision and a case of consequence comes out, some precedent that should be impactful or known to the bench? Or do you just assume that the judges' clerks are on top of these things and keeping the judges apprised about developments in the law?
No, I mean, I think it's important as the advocate to keep the court up to date. It is likely that they will know. I think the courts are very careful to keep up to speed, but you need to let them know about the decision and briefly how you think it impacts the case that you have before the court. It doesn't have to be long, but typically there is a procedure where the court's rules allow you to present new cases that have come to light after oral argument. So you should take that step.
And Justice Connors, same advice from you? Do you like to be kept apprised of precedent post-argument?
Well, yes, don't flood us. I think the federal courts call this a 28J letter. And so you don't want to be filing one every week. But if something really comes up and you can follow the rules, it's like less than 350 words. And this is slightly tangential, but to your question, but we do our best not to have a surprise when you stand up there for oral argument. Like, have somebody, here's one of your biggest fears as an appellate arguer. Nothing's been briefed on this, and one of the judges goes, but do we really have jurisdiction here? That is your nightmare. And I know that whenever Judge Lynch on the First Circuit would not get an answer, and she's still on the bench, you didn't have an answer to a question. What you should do is say, I'd be happy to file a 28J letter on that point with a response. Now, 28J doesn't really fit this, but that's the vocabulary you would use for her. With us, you can say, I would I can write a letter or a supplemental brief. Don't be shy. You can ask. We might say no, but it can't hurt to ask if you are totally deer in the headlights.
So we're going to turn to Q&A in just one moment. If you have, by the way, in the audience, if you have questions and you don't want to raise your hand, feel free to just drop it in the chat as well, and I'll be happy to read from the chat with questions. And Justice Meade, I'll give you the last word on this question about supplementing post-argument with precedent and case developments. What's your...
We have Appellate Rule 16L, and that allows lawyers to submit supplemental authority after argument, and you're to indicate where in your brief this would have supported the argument. You're not supposed to write any argument in the letter, but lawyers violate that all the time. Sometimes there's a request from the bench for something, and you can file a letter under Rule 22, and you should explain the opening sentence that the court requested this information, and that's why I'm providing it.
Fantastic. Well, thank you. Thank you. We'll turn it now just for some Q&A. If you have a question, if you're on the lower right-hand side of your Zoom screen, there's 3 dots for more. And if you click on that, you'll see about 2/3 of the way down, raise hand. Just click on the raise hand icon and we'll call on you, or you're welcome to put questions in the chat as well. So we'll just give folks a moment. While we're waiting for some hands to rise, I'm curious, Josh, have you ever contacted a clerk some months after a case was under advisement to ask about the, when can we expect a decision? Typically cases are decided 3, maybe 4 months after argument in most courts, but sometimes you might get to 6 months, 8 months, maybe longer. At what point does counsel ever, if ever, inquire of the court about, what's the holdup here?
I'm pretty reticent to do that. It's a little bit of a risky ask in my view. Now, if you have a good relationship with the clerk's office, it's possible to give a call and find where things stand. But typically, I think it's incumbent on the attorney to let the court know in advance if there is, a particular time concern, a reason for a decision and a time sensitivity. Otherwise, you're just annoying the court. And one of the hardest things, I think, it's difficult to prepare for argument. It's difficult to write a good brief. Probably the most difficult thing is just exercising patience to hear the answer. But that's probably what you need to do, is just exercise patience.
So all 3 of you, thank you, Josh. All 3 of you at various points in your careers have been advocates, appellate advocates in federal court as well as in state court. And I'm just curious, not necessarily from your state judicial service, but what are the differences in appellate advocacy between state and federal courts? Is it simply 2 different systems and basically same ground rules apply, or is there a different way to approach federal judges and federal appeals? Justice Connors, I'll start with you.
Well, there's obviously commonality. You're going to know who your judges are with the Maine Supreme Court. You don't know who your judges are on your panel with the First Circuit, at least until a week before. And the senior person on that panel is going to be the one that assigns the case, who gets to write the opinion. So there are some nuances that are different. And also, of course, they have many more resources than the state system. So they're going to have at least four clerks writing memos or whatever they want, while we're going to be a little bit more streamlined. And so it makes sense to keep that in mind. And you get to know the personalities of the people who will get to be on your panel. That when you, so by the time you find out who the panel is in the Court of Appeals, you know how to orient. Well, you're not going to have that step when it comes to the law court.
Justice Meade, in your prior practice in federal court, any discernible differences in your opinion?
I argued many cases in the First Circuit, and the thing that I appreciated, and I compared it to my own court, is they were always extremely well prepared. They knew what the case was about. They knew where the weaknesses were. I enjoyed arguing there very much. The judges there are brilliant. and fun to appear in front of. In the early days of my career, our SJC was a very cold bench. And it was very difficult to argue there. As my understanding, they didn't read the briefs ahead of time, and they only had bench memos. And if they asked you a question, it was usually based on the record and was factual. So, try to stand there and give an uninterrupted speech for 15 minutes, as Josh was talking about. You gotta know when to sit down quickly. I teach my students that if you see an opportunity to sit down, take it. You don't want to waste your time up there snatching defeat from the jaws of victory. But overall, there is nowadays. I don't think there's. Of course, I'm not practicing in federal court or state court for that matter, but I don't think there's a big difference.
Yeah, Judge Young of the U.S. District Court in Massachusetts used to say, because he was a state superior court judge before he became an Article III judge, and he always said that it was always much more fun to be a judge for the sovereign that prints money in terms of resources. Josh, what's your take? Any discernible difference that you would share that from what we've already shared here on the state side with federal practice?
No, I would agree that those are the key differences. I clerked at the federal appellate court level, and I think the key difference is likely the amount of resources. And it was our practice in Judge Kelly's chambers that he would get bench memos on each case, each significant case, and that clerk would likely be the one who would end up preparing first drafts for the judge's review and the like. So there's more attention given, and as a result, as Justice Meade highlighted, the judges are very prepared. So just coming in and trying to lay basic groundwork is not a good use of your time, because they're going to be prepared. They want to talk about the difficult issues.
So I don't see any hands that are raised on the screen, and Elizabeth, you can jump in and let me know if I'm missing something. I just want to, with the few minutes that remain, I'm curious, Justice Connors, do amicus briefs help the court? Can they assist the court in making a decision? Do judges even read amicus briefs? Just curious about your experience with this.
Oh, yes. And I think they can be very useful, and we like them. And I don't think we like them quite as much as the Massachusetts Supreme Judicial Court, because I saw a statistic once that they ask for them like in 40% of their cases.
They do.
But they're a discretionary court. I mean, we get all comers. And so if it's just a fact check, we won't need it. But they're particularly useful if it's an area of the law that is kind of very specialized. It would be nice to hear from that section of the bar, like a probate issue or a real estate title issue, something like that, to get some probate organization to tell us so that we don't make mistakes. That's very useful. And beyond that, constitutional issues, just don't make the amicus brief repetitive of the party brief. They should supplement the brief, not bring up a new argument, but they can, the implications of one answer versus the other, a deeper dive into legislative history, things like that, and talking about the implications of going one way or the other.
Justice Meade, we talked earlier before the session started about amicus briefs in the Massachusetts Appeals Court. It's not as common, I take it.
No, we're in the middle of I hope it's more towards the end of the middle of an en banc pilot. And we heard a case en banc involving a housing issue, and there was time for interested people to send in amicus briefs, and I believe we received 3 from special interest groups and the attorney general. So it was interesting to see those. None of them were helpful to my view in the case. I dissented. In general, the way arguments are scheduled for us, there's insufficient time for amici to submit everything, and by the time the cases are assigned for argument, even if it's a couple months ahead of time.
Okay, well, thank you, Justice Meade. And we have, believe it or not, come to the end of the hour. I want to thank Justice Catherine Connors from the Maine Supreme Judicial Court, Justice William Meade from the Massachusetts Appeals Court, and the chair of this CLE. This was your brainchild, Josh. I think it was a fantastic job. Josh Dunlap from the Pierce Atwood office in Maine. And I want to thank all of you for joining us here today at the New England Legal Foundation. You can look at other events coming up in 2024, believe it or not. It's almost 2024 at newenglandlegal.org at our events page. And you're welcome to join us for future CLEs as well as professional networking. That will wrap up this CLE seminar. I'm Dan Winslow for the New England Legal Foundation. Thanks so much. Thanks for joining us all. Appreciate it.